Hello, my name is Kristen Harper. I'm the Policy Director for Arkansas Advocates for Children and Families, and I've been asked to talk to you a little bit about some of the highs and lows of the 2025 legislative session as it pertains to juvenile justice. One of the highs was Act 988, which requires the court, when they're sentencing a juvenile, to consider any adverse childhood experiences, sometimes called ACEs, when they're making that sentencing decision. So that can include things like any time in foster care or other trauma that person may have had and what that impact of the trauma on their behavior was. There's also a House concurrent resolution passed during the session that will require a study of the juvenile justice system, and specifically youth who are committed to the Division of Youth Services, to determine ways that we can improve that system. And Arkansas Advocates is actually named in that concurrent resolution, and so once that gets started, we will be a part of that and coming together with other stakeholders and experts to make recommendations of how to improve juvenile justice in our state. There was a missed opportunity. Senate Bill 340 would have eliminated fines and fees for juveniles. So right now, in many cases, courts will charge fines or fees to juveniles who are being heard for delinquency cases. Sometimes these fees are not very much. They can be as little as $10, for example. However, for some families, that $10 can mean the difference between paying a light bill or putting food on the table that particular week. So we argue that fines and fees don't produce the outcomes that we would like to see. They don't help to rehabilitate a youth and becomes more of a burden to the family. Another challenge is the courts can spend a lot of time trying to collect those fees, and so the amount of resources that go into trying to collect those fees and what actually comes in is not worth the effort. And so unfortunately, this bill did not pass to eliminate fines and fees in Arkansas.